You made,
Thank you.
and we would now like to invite one more panelist to join you to continue the discussion.
Sure.
Thank you so much, Mr. Tankha. Some pertinent points there raised, and we will of course be taking that forward with Shri Aman Lekhi, former ASG and senior advocate, who also joins us at the third Law and Constitution Dialogue. Tarun was just having a conversation about whether parliamentarians are doing a good enough job of drafting the laws which seem to be clogging up our courts. So, Tarun, taking that conversation forward, we will of course be discussing the 3 new laws that have been introduced. Are they addressing the deficiencies of the past? Tarun, over to you.
Thank you. Thank you. So we continue our conversation. Of course, we have the benefit of having senior advocate Aman Lekhi, who has defended the government as the additional Solicitor General of India for many years, and so we will get both sides from the prosecution side as well as from somebody who defends people in court on a day-to-day basis, MP and also senior advocate. Your first comment on the 3 new criminal laws, and then we'll go to senior advocate Aman Lekhi.
On the 3 criminal laws. Frankly speaking, what was the need to change? I mean, today, everybody is trying to find out which law now I have to apply in this case, because the numbers have changed. What was the need to change numbers? Why are you making things difficult for the entire legal law fraternity, judges, students, policemen, everybody? I mean, frankly speaking, you've changed things for the street. I'm always a votary. I welcome change. Change always must be for betterment, for good. Now, if you are going to amend 6 or 7 or 8 sections of Evidence Act, and you repeal the entire act and bring in a new law, 80% of the old sections are only renumbered. What is this change you're talking about? This is not a change. Only thing is you make things difficult for everybody.
So you mean India has not given itself a new law? That is
no. You have given a new law, but the new law is actually the old law with a few changes. So you could have amended the old law. You wanted to change the name. You could have changed the name of the old law. Who stops you? So what I say is, every time to say that I'm going to bring a new thing is not an acceptable way of changing.
Point very well taken. We will now take the introductory comment for senior advocate Aman Lekhi. Of course, now you are appearing, you're no more ASG, so now you're appearing in your defense counsel.
Let me first clarify. Even as an ASG, it's not as if you take sides. In fact, the role of a law officer of the government is not to be partisan.
Yes.
So, and I've never been partisan. And that's one of the reasons why I left. So anyway, that's a different story altogether. I broadly agree with Mr. Tankha, but I'll be slightly more emphatic. I personally feel that as to the criticisms of the old laws are concerned, it's criticism of the uninitiated in law. And it is wholly unwarranted, totally unjustified, and utterly gratuitous. What it shows is betrays ignorance of our legal system. To denounce it as colonial is utterly wrong, totally wrong. And the greatest testimony to this particular fact is the remodel laws, which more or less, as Mr. Tankha said, continue the old law. So that is something, that's a reality which you cannot in any way move away from. Now, what is very important is, if you look at the 3 laws, insofar as the Evidence Act is concerned, the principles of the Evidence Act, there are certain fundamental principles of the Evidence Act, which remain unchanged in the new laws, because relevance, admissibility, best evidence, these are the 3 principles continued. Insofar as the CRPC is concerned, to say the CRPC is a colonial construct is baffling, because the 1898 code, which is the pre-independence one, was substituted by the 73 code. That is way into independent India. And there have been 3 law commission reports dealing with that, all Indian. Insofar as the IPC is concerned, in the 160 years, 170 years the IPC was there, there has been no major change. Even in fact, the changes that have been made in the current code, in my opinion, are not changes which are in any way in advance of what should be done, but are in some way extremely retrogressive, if not at times utterly stupid. In the sense that if you look at terrorism, terrorism is in an offense dating to harm to body. Now you cannot possibly have terrorism and harm to body. So the basic understanding of the placement of the sections, which is what is being reorganized, is utterly wrong. And finally, when you look at what is this is recodification. As far as recodification is concerned, it's a massive exercise. It is supposed to address it for the purposes of, in some way, dealing with the anomalies which are there. Now, far from addressing the anomalies, it has created more anomalies. And I can carry on. So as far as this particular approach is concerned, I personally feel it is unnecessary. And as Mr. Tanka said, 80%, I don't think it's 80%. In fact, it's more than 95% of the law is more or less the same. 80% is an understatement. And except for a few changes, say in the illustrations or marginal notes or grammatical mistakes, there is no other change in the law.
One thing that we have noticed that people have praised the new laws a lot for the use of DNA evidence. Every police station in the country will have a team that will go to the crime scene, protect the crime scene, and earlier the evidence was ocular, which means the policeman, for the benefit of my audience, the policeman used to beat out and take a confession, but now DNA evidence has been made compulsory, so every police station I will have a DNA party, they will go take evidence, and that will in the end aid the prosecution in proving their case. Do you think that's one of the good aspects of this law?
The law always evolves. Tarun, there is nothing wrong in bringing in new scientific methodologies of investigation. I mean, today it's DNA, tomorrow it will be something more. So this evolution was coming all the time. I mean, if it happened so many times, there were amendments, presumptions change also many times. So what we are, as he rightly says, all this could have been just brought as an amendment. You don't need to change the book. You need to change 2 lines. That could have been just an amendment and everything else would have remained the same.
Point well taken. I'll go to Senior Advocate Aman Lekhi.
I really don't see. See, there are rhetorical flourishes which I feel make more of political than legal statements. You have timelines, you have DNA and everything. It's not as if there was no DNA evidence before the amendment. It is part of the investigatory process. And now it's not enough merely to have some DNA evidence. You need to have...
There is one topic also that we are now witnessing on a day-to-day basis is this criticism of judges on social media. Suddenly we see a judge makes a comment in Supreme Court and there are armies of people who start to criticize a judge, and of course judges have also spoken about it, that trolling happens. Since you're an eminent parliamentarian and you see this issue from, the perspective of, parliamentarians can speak out. Lawyers can speak out. Judges can't speak out. Anything you want to speak on behalf of the judges or your comment on this?
These are two separate issues. One is when you are sitting in a court as a judge,
yes,
you have to be careful about what you say and speak. You can't be taking sides. You have to hear 2 sides, look at the law and decide the matter. I am a votary of independent judiciary.
Okay.
I am a complete votary of independent. It doesn't matter which party is in power. If there is no independent judiciary, there is no democracy to begin with. And if you want to keep our fundamental rights and our rights safe, you need independent judiciary, always. It doesn't matter whether he's practicing or I'm practicing or who's practicing. Number 2, if you are moderate in your language, nobody is going to troll you.
Is it?
If you come with those flourishes and say awkward things, they get reported and people troll you. So if you are going to speak, don't be scared then don't be concerned that people troll you. I feel that judges are open to public criticism. They should be open, they are like everybody else. In fact, I say that even the law of contempt is an archaic law. You don't have contempt law in US. If you are good, if you are correct, what you are saying or doing is correct, people will judge you. You should not be bothered if 1 or 2 people find you wrong. So my issue is that judges should not be concerned about being trolled. My thing is you should be open to criticism, and this is a public position, a public post. You are deciding rights of common man. So obviously people have a right to speak about you.
Point very taken. So on criticism of judges on the social media, Senior Advocate Aman Lekhi will say.
Well, I personally feel criticism is basically euphemism for ideologically driven agendas. I personally feel that is so. We have, insofar as those I'll put the expression criticizing in inverted commas, we choose episodes and events on which we speak. And the choice of those elements is an element of gatekeeping. Now, gatekeeping is supposed to construct discourse in a particular way. So you highlight certain aspects so as to either divert attention from others or needlessly focus on issues which can be best avoided or be treated as non-issues. As far as criticism is concerned, I don't think judges can be averse to criticism or criticism of judges is unwarranted. What I am against is the use of criticism to promote an agenda. Okay. And insofar as that question is concerned, that you cannot have a general proposition that you can't do this and you can do that, because insofar as speech is concerned, drawing of lines is completely unwarranted. It has to be done on an individual basis. To the extent it is unnecessary, criticize it. If it is not, welcome it.
Thank you. Thank you. I would like to thank Senior Advocate and Member of Parliament, Mr. Vivek Tankha, Senior Advocate Aman Lekhi for coming here, for making time and speaking on important issues related to judiciary, related to Parliament. It was a pleasure having both of you. Thank you so much for coming. Thank you so much.
Could I request Kartikeya Sharma ji to kindly come on stage? Gentlemen, please stay for a second. We have a special Forget Us Not. It's a monogrammed copy of the calligraphy edition which weighs 5 kilos of the Constitution of India. So you've heard it, the calligraphy has been done by an individual from Jabalpur, which of course is hometown for Mr. Vivek Tankha. Round of applause, please. They're also getting a framed copy of a photograph of the first Constituent Assembly meeting held in 1946. And a copy also for Senior Advocate and former Additional Solicitor General, Mr. Aman Lekhi. Sir, appreciate you taking out the time.